Welcome to Business Masters, the podcast that gives you direct access to world-leading experts on key business issues. To be the first to know about future shows and to access even more exclusive content, visit businessblueprint.com and subscribe today.
Hello, it's Dale Beaumont here, founder of Business Blueprint, and welcome to another Business Masters podcast. Today I'm talking with intellectual property expert Geoff Moller, and our subject today is how to protect your intellectual property. Geoff, thanks for joining us.
Hi Dale, thank you for having me.
So first of all, let's bring everybody up to speed. How do you define intellectual property as it relates to a business?
Intellectual property describes things which are created with the mind, which are new or original. And in business, it can take a number of different forms. It can be a new invention, a brand, a design, an artistic work or creation, even music, art, or a book even.
Okay, and can you give us some examples of what would be listed under a company's intellectual property? You've mentioned some things like, brand. I'm guessing, can you even do things like colors and fonts and logos and even sounds?
Yeah, there's a number of things you can actually trademark, and the type of things include a business name, a logo, and a color, even a sound can be trademarked, a smell, a shape, a picture, or a combination of these. Most commonly, though, people like to trademark or protect their business brand and a logo, which is typically a composite logo, which might include like an image, but included with that is the actual business brand or the product brand as well. Some people are happy not to register or protect their business name, although most do, because it's really about what you're marketing. And so if you're marketing a product or a service, and that's going to the market, and that's the brand you want to protect, and that's typically what people will apply for in a trademark.
And why would a business, go to the effort of doing this whole process, apart from, kind of the obvious about, protecting your business and maybe trying to distance yourself from other competitors? But are there any other reasons that we should be thinking of?
Absolutely. And the question I ask people is, what happens if you don't apply for a trademark? And people invest quite a lot of time and money into building up their business name or their brand, but don't apply for a trademark. And so what can happen is that you can spend, or a couple can spend, enormous amounts of time and money building up their brand, only to find that someone else has seen their idea or success and then applied for a trademark. And if the other people get a trademark, that really puts their concept, their business or brand at risk, because the other people can just go about using that brand or trademark at will. And I see that quite a lot. People just don't act early enough in applying for or protecting their intellectual property around their branding.
I'm guessing it does make your company more valuable as well, because it does have a tangible value, those trademarks and protections. Absolutely.
It is a true asset, and it does accumulate value over time in the fact you're just running your business on a day-to-day basis. To give you an idea, when Zups sold their business many, many years ago up here in Queensland, we don't know what they got for their buildings and their stock and their cars and their computer systems. We just don't know that. But I do know that when they sold their trademark, their intellectual property, their brand, it was a separate negotiation based on their legal structure, and they got $177 million for it. So trademarks and intellectual property assumes value.
Fantastic. Now, what are the things that we do need to go through a formal process in order to protect and to make sure that we have either trademarks or patents and those type of things versus things that are just protected anyway by just kind of common law?
Okay. There are some things you can apply for through a formal process of registration, examination, and success in actually getting it through. Other things which you don't have to register are copyright, and that covers books, articles, artwork, images, designs. Copyright is automatic and quite protected in about 70 countries around the world. It's automatic. You can register copyright in America, but you don't have to. In Australia, you can't register copyright. So they're the things you don't have to register. But things like patents, trademarks, designs, and plant breeders' rights actually have a formal application, examination, and registration process. When you look at going through the process of applying for a trademark, And as you mentioned when we started talking, a trademark is really about distinguishing your brand or product from everybody else's, and then protecting that. So when you apply for or look to think about applying for a trademark, you need to determine what kind of intellectual property you're trying to protect. Is this something you need to register, or is it something which is automatically protected, say, for example, under copyright? Graphic designers, for example, when they do their work, all their work's protected under copyright, as is the photographers, somebody does an artwork or a song
Or a video,
or write a
perhaps.
book. Absolutely, yeah, it's all protected automatically. But
Okay.
when you do a trademark, you need to determine first of all what kind of IP it is. There's 45 classifications of trademarks in Australia. It's a very convoluted database, so you just got to work out which classifications you need to protect your trademark in, and you then need to do the searches to find out, make sure you're not infringing somebody else's trademark already. Then you look at the application process. You have to wait. It's a 7.5 month minimum process to apply for a trademark. So it has to go through that assessment process. And there's also an opposition period in there where people who think you may be applying for a trademark which is too close to their own, or in the international company, can actually object to your application as well. And then at the end of the 7.5 months, usually I find about 8 months, there's a registration. And once you register the trademark, you're protected for 10 years before a renewal fee is due again.
Now, and there will be people listening to this interview from other parts of the world, for US, New Zealand, UK, maybe even Singapore. Now, each country has its own kind of laws and rules, and also its own governing body that oversees the application process. Do you know what some of those other entities are? And you have to apply to each of them separately. Is that correct?
Yes, you do. Although, if you're doing a number of countries, there is what they call a Madrid Protocol, where you can apply to a number of countries at one time. And to give you an idea, from Australia, if I was to apply for one trademark item, either a name or a logo, and I applied for all the countries which are covered under the Madrid Protocol, it would cost me around $25,000 just in government fees. Every country has their own sovereignty, those with trademarks, whether it's Australia, New Zealand, the US, and the EU tend to do it in a more shared environment. When you look at overseas, though, it's very, very important, I believe, to get an IP professional or IP lawyer to help you. In Australia, the process is a bit simpler, and same with New Zealand as well. So the process is not too hard, but when you multiply the 45 categories in Australia, for example, with the other countries and how they do things, then there's definitely a more complex process involved in applying for multiple countries at the same time.
Okay, so in Australia, I think the website is ipaustralia.gov.au. And you can go on the website, lots of free information on that website. Do you know the websites for, say, the US and the UK?
Oh, sorry, Dan, I can't tell you that at the moment. But if you go to the ipaustralia.gov.au website, they actually have links to the Madrid Protocol and the US trademarks database as well, and also to the New Zealand, I think, as well, is on that website as well. So IP Australia is a good jumping off point for many of the jurisdictions and sovereign trademark application processes around the world.
Yeah. Now, you mentioned these things called classes because 7 years ago when I registered my first trademark, I just assumed that I'd own it for everything, but that wasn't the case, that that there are these things called classes. Can you explain what they actually are, and why can't we own our name for everything?
It's interesting, the classifications or categories or classes. They've been around since before the days of Einstein, and it's really to help separate from a consumer's point of view where a business's brand fits into the marketplace. Say, for example, if I was a caravan manufacturer, well, that would be certainly different from an accounting firm. So I might be able to have a similar or the same name in one classification as a caravan manufacturer, and as an accounting firm, I can have the same name, and it's obvious that the consumer is not going to be confused. So they have broken it down into 45 classifications. The first 34 are to do with product, and the 35 and above are to do with services. So, for example, construction versus applying tools for construction. They're all different. It is a very convoluted database. So what we would think of in search engine optimization or search engine marketing, or what we've become used to, It's very different from the trademarks database. It's very convoluted, and there are things which are in one category which you wouldn't necessarily associate, and things which you think would be together which aren't in one category. You've got to apply for multiple categories. A lot of people are becoming involved with, say, newsletters, online publications, blogs. They all have been allocated into various classifications and categories. And the goal when you're applying for a trademark is often to look at the most appropriate classifications to protect, but minimizing the amount of money you're going to invest to apply for a trademark, because it can get very, very expensive. So I find when I work with people in trademarks, there's usually 2 to 3 classifications that apply. For some people, it could be 5 or 7, but certainly never 45.
And so there's a fee, there's a one-time fee for the trademark process, but then there's another fee per class. And so that's why you're saying sort of to limit the number. And I suppose the more you try and do, the more objections you'll run into and the harder it will be to get through. Is that correct?
That's exactly right. For each classification, there's a application fee per item. So, for example, if you look at a brand name, that's one item. If you look at a logo, that's another item. So therefore, that's 2 items. If you look at 2 categories, that's actually 4 times the fee of $200 for the application fee. And there's actually 3 ways you can apply it. So the fee does vary depending on which way you apply. In 8 months' time, to complete the registration process in Australia, it's $300 per item per class. So that's why it's important to do all the work well before you actually apply, to know exactly the categories or classifications you're going to apply in before you put the money over. Because I have come across people I've helped who've actually applied, and then they found out they've actually applied for the wrong category and had to start again.
And what do you do if in this process, you uncover that there's someone trading with a similar name that already has a trademark in place? Do you try and change your name? Do you try and get it through, but with kind of less classes? What do you do if you run into some obstacles?
Usually, well, again, I'll talk about Australia, but all jurisdictions are very similar. When you apply, IP Australia, in this example, would say, no, you can't have the trademark because somebody else already owns it in the same class or a related class similar to what you're doing. And they would just knock it back. And it depends on who started using the trademark first, whether it's a registered trademark or just a trademark that people have been using in their day-to-day business. What would happen is that if you started before the other people, if you started using your trademark before the other people, you can argue the case that say, well, no, I've been using this trademark for the last 5-10 years. These other people have only registered, for example, in the last 2 years, and then you can argue your case to apply for, and then prove that you should have the right to now own that. The issue is that when you don't apply for a trademark and someone else does, it puts you on the back foot. So it becomes much more expensive very quickly to actually now turn around and prove that you should also own the trademark, even though you've been using it for a long, long time. So although there are government fees and the cost of helping or having a professional help, it's much, much cheaper than actually going the other way and then having to prove that you should have the right to own that trademark at the same time.
And I see some people, they put the little TM next to their logos. Then there's other people that have C's, other people that have R's. Can you explain what all those sort of symbols mean? And can anyone just put on any of those things they like, or is there a process?
Oh, that's a great question, Dale, because it often comes up in a lot of in the work I do, that people say, well, I saw a TM there, or I want to use the TM, but I'm not quite sure. In Australia, when you see a TM, it actually means nothing legally in Australia at all. Anybody can put a TM next to anything. Of course, you don't want to be infringing someone else's trademark, but you can put a TM next to anything, and it might indicate to people that, yeah, you've got a trademark application in process, or it's just an unregistered trademark. You can do that with anything you want. If you put an R, which is usually the R in a circle next to a logo, symbol, word, then that means or indicates that you have a fully registered trademark. And it's very important that you don't put that on something where it's not registered, because it can mean up to 3 years in jail and up to $50,000 fines for telling people you've got a registered trademark when in actual fact you don't. So it's very, very important you never use the R in a symbol unless it's registered. The TM in Australia has no legal bearing and means really nothing here as far as IP Australia goes.
Now, you mentioned this kind of period that could last, 7 or 8 months before it does get registered, and there's a period where people can object to it. What happens if people object? And also, what happens if you're on the flip side of that, meaning you've got your trademark through, it's been successful, and then how do you know if someone else is coming behind you trying to register something similar? How do you get kind of notified about this, apart from, looking at their journals and reading them every month? How do you know what's kind of going through after you?
Yeah, look, another great question. I see this all the time from both sides. What happens is that IP Australia don't let you know. I mean, if you are protecting your trademark, I would say 3 months at least, you'll just go online, do a quick search to make sure no one's applied for something similar or the same as what you have. And at that point, you can lodge an objection, or someone can lodge an objection against your trademark application. So whether they're an Australian company or an international company, they can actually lodge an objection. It does cost money. It's not a free thing at all. And if someone, for example, if someone lodges an objection against you or someone applying for a trademark, they have to do it within, now it's only just changed in the last couple of weeks, within two months of the final 7.5 months of an application process. They only get 2 months to lodge the application, and they have to pay a fee to do it. Once that's done, that person then has to come up with the evidence of why you shouldn't have that trademark you've applied for, and vice versa. If you object to someone's trademark application, you have to come up with a reason why they shouldn't have that trademark. So you can't just lodge an application and just think that it's all going to be fought on your behalf, because there are costs which will be awarded against you if you lose. So you've got to be very, very careful about that.
Okay, and this may be starting to sound a bit complicated for a lot of people listening to this, going, gee, how am I going to do this myself? Do you recommend people should do it themselves? Get a consultant perhaps that's been through this process many times before, or a professional legal firm? Who's the best person to go to get some advice around their individual circumstances, and then get the whole process, through?
Yeah, okay. There's probably 3 ways you could do this. And there's a DIY, do it yourself, and IP Australia have some very good information about how to actually lodge the application online. There's workshops you can do and attend, which then give you a deeper understanding of the whole process, and especially some of the pitfalls involved. And a lot of workshops will share case studies about, well, what can happen in this scenario, and what has happened, and what's been the outcome. And the case studies and the stories are very, very powerful learning tools in my mind. And the third way is to engage an IP professional. So it can be someone who specializes in intellectual property and trademarks. It can be an IP attorney, and it can be a legal firm. So there's 3 definitely different ways there to get professional support. Plus there's a DIY and the workshops as well, which will help lead people through the process and explain all the steps along the way.
And a lot of people, they get very excited when they think about trademarks and worldwide expansion. Should people be thinking globally from the beginning, or should they just, focus on building their core kind of country and market, getting that strong, and then, spending the $25,000 later on down the track once they're a bit more established?
Yes. I think there's a good strategic discussion around this. I've heard people talk about, get it in place early, and certainly that's what I do personally. I always do my due diligence, get things underway, and I often wait until the trademark application process is complete before I bring it to market, and a lot of people I work with do that. Other people want to test the market, get it into the market first, and then apply for a trademark once they know it's going to be successful. Other people start off with an exit strategy straight up front. So they have their business plan. They say, well, my exit strategy is going to be this. So I actually have a plan. And then sometimes they say, well, I'll get the trademarks in place, make sure that's done, because that'll create value for the business. And by the way, if a business doesn't have a trademark and someone comes to buy the business off, the first thing they'll ask is, well, who owns the IP or intellectual property around this business brand or name? And if you say, well, no, we haven't bothered, it immediately devalues the business straight away, because there's no protection around the IP or the brand. So with the exit strategy in place, some of the more entrepreneurial and worldwide thinkers think, well, I'm going to get everything in place, but I don't think I'll ever have to defend my trademark, because that's not my job. My job is really to create the wealth or the program. And then it'll be up to the next person or the float or the company that buys my business who will have to defend eventually defend the trademark if ever that case, that time comes.
Okay, we're almost out of time. Do you have any kind of final thoughts or kind of, words of wisdom to close?
Yeah, I encourage people to look at the trademarks and the intellectual property very early in their business planning. Look at that as part of your business plan or business planning, and then determine what kind of intellectual property will the business need, or intellectual property protection the business will need, what kind of intellectual property will it end up with eventually, and then go immediately into steps to protect that IP, because in today's world, IP will give a competitive advantage, as well as it'll add value to the business in the long term. But we spoke about trademarks, but there's also domain names related to trademarks, the way Google handles trademark or IP as well. It's a big trap there if you don't have a trademark. 1-300 numbers, customer list, a whole lot of things are under that IP classification. And the business plan, in my mind, should really cover all those things as part of the normal things you do in a business plan now. And I'll just finish up by saying that with search engine optimization and search engine marketing, one of the things is that it can work very effectively, and we go out of our way to be found online. But the trouble is, because we get found online, it can also give us problems with intellectual property and trademarks, and also infringing somebody else's trademark as well. So one way, what was acceptable several years ago with trademarks and intellectual property is not acceptable today. Very different world today because of the fact we do want to get found online. We do use those tools and the internet to further our business, but at the same time, we then have to be more clever about how we protect or secure our intellectual property.
Geoff, it's been a pleasure chatting.
Thank you, Dale. Thank you for allowing me to share my thoughts on IP. I love talking about the subject.
For more information about Geoff Moller, please visit geoffmoller.com.
Thanks for listening to another Business Masters podcast. To access more great content or to download your free business plan template, visit businessblueprint.com.